was so popular that these events are sold out within an hour. I mean, it's not sold out, but they're registered within an hour. So we need to build an addition to our association here or something. So Daniel has graciously come back to do a repeat of this, and we all know and love Daniel, who does a fabulous job with all of our rent control and landlord-tenant issues and so forth. So without further ado, Daniel, thank you very much. Let's give a warm welcome to Daniel.
Thank you, Betty. It's actually my pleasure to be invited among you folks. So I'm thrilled to be able to conduct a seminar, or at least a workshop. All of the material that I'm going to be presenting up on the slide are in your materials. And the hope is that after we're done here by about 4:30, you will feel really thrilled that you came here to do some real quick, intensive learning. And the whole goal is for you to come away from here being able to look at a property in San Francisco, know whether it's subject to the rent control laws, know whether it's subject to just cause eviction control. And I'm going to give you a window on how I look at real estate in San Francisco from both an attorney perspective and also a broker perspective. For many of you, you know me as an attorney. I'm also a broker with Bay Property Group. And my goal today is simply to teach you about how I look at a property and how to evaluate what's possible. And the assumption is as follows. If you understand the rent ordinance and understand the nuances of the rent ordinance, you will be at a strategic advantage over those other agents or investors who simply have a ambivalent or ambiguous understanding of the ordinance. What I have done with Bay Property Group and Bornstein, I've been practicing for 20 years, is there is so much confusion out there. The rent ordinance is so complex. What I've tried to do is develop cheat sheets and materials that are digestible for agents and for investors and for your clientele, so that they too can go through and look at a property and know what can be done and what can't be done. So with that stated, what I'm going to do is just point out what we're going to cover today, and then we will cover it. And what I'd ask is, because I know that this discussion engenders a lot of questions, save them for the end of the discussion, and I will answer any question that comes in, and I will leave myself available to answer particular questions that you may have as well. For those of you who are filtering in now, I want to make sure you all get handouts so that you can follow along. Perfect. And so I should be talking for about 45 minutes to an hour. If I go too quick, just raise your hand. I'll repeat myself. The whole goal of today is for you to walk out of here saying, man, that was helpful. So with that stated, I'm Daniel Bornstein. Of course, with Bornstein & Bornstein, we have offices in Oakland and in San Francisco. And today what we're going to focus on for you real estate agents in San Francisco is San Francisco rent control, the new rules, regulations, disclosure obligations, owner move-in evictions, and RMIs, which are relative move-in evictions, a discussion of protected tenants, what is a protected tenant, termination of tenancy process, the new tenant buyout agreements, a little bit about Airbnb, and then a final discussion. And if we can get through this rapidly, I think you're going to be very pleased of this talk. So let's jump in. Many of you have seen this chart before. Some of you haven't. Please, if you look in your materials, you'll see a chart that said San Francisco rent control cheat sheet. If at minimum you're able to come out of here understanding this cheat sheet, you're well ahead of the game. And what I mean by that is if I at a convention talk to 10 San Francisco real estate agents and I ask them about rent control and just cause evictions and rent regulation, and I ask them about this chart, I would say maybe 2 to 3 out of 10 would be able to really hit this spot on. The expectation today is that all of you walking out of here will be able to do this. So, with that stated, when I talk about rent control in San Francisco, we have to remember we're delineating between two different things, rent regulation and just cause eviction control. So if you see a listing that says subject to tenants' rights and rent control, you better in your mind be able to say, well, there's two components of rent control. rent regulation, and eviction rules. The bottom part of this cheat sheet is easy. The bottom part of this cheat sheet is easy. Whenever I look at a property, whenever someone calls me up in my office and says, Mr. Bornstein, I have a landlord-tenant problem in San Francisco, do you know what the first thing I say to them is? When was the property built? If it was built before June of 1979, that's important. If it was built in June of 2003, that's important. We always look at the start of this chart and ask ourselves, when was the property built? If the certificate of occupancy was issued June of 1979 or after, June 13th, 1979 or after, there is no rent regulation, no eviction control, no protected tenants, no relocation payments. All we look at is whether we've got a month-to-month tenant or is the tenant on a fixed-term lease. Doesn't matter if it's a single-family home, a multi-unit property, there is no rent control, there is no relocation payments, there's no protected tenants. If you don't want aggravation in your rental or real estate career, focus on new construction. Right? South of Market, condos, there's a lot of brokers who just focus down there and they do real well and they have no obligation to deal with the nuances of the ordinance. However, if you're representing a buyer, you're paying for that post-79 property because you're paying for what? To be free from regulation. Price per square foot, price per unit, much higher because it's not subject to the rent ordinance. Got it? So whenever someone says, I want you to represent me in a sale of a property, the first thing you need to know is, when was the property built? June of 1979 is the cutoff date. If someone says approximately the summer of 1979, you want to get that certificate of occupancy so you can see if it says June 13th or June 30th. It's a big date difference. So I'm always, if you call me up and say, Mr. Bornstein, I have a client who's going to be buying a property and we need to know what to do, I'm going to first say, when was the property built? Built after June of 1979, no rent control, no eviction control, no worry about protected tenants, simply are they month-to-month tenants or on a fixed-term lease. The top portion of the chart is where it gets interesting. The top portion is where people get confused. Most properties in San Francisco were built before 1979. Duplexes, triplexes, single-family homes. If we have a multi-unit property built before June of 1979, duplex, triplex, 10-unit, 20-unit, single-family home with illegal in-law unit, if it was built before 1979, if it's treated as a multi-unit property, we have rent regulation and we have just cause eviction rules. Rent regulation and just cause eviction rules. That means you must follow the rent ordinance for rent increases and you must have a just cause to evict. If you want to sell a property, a duplex, before 1979, and the tenants are month to month, can you terminate the tenancy just because you want to sell the property? No. And I would say I have that conversation with someone once every 2 weeks. They call me up, they're in Texas, they say, I've got a property I inherited from my parents, I want to sell it, can you help me terminate the tenancies? What do I say? When was the property built? Oh, 1950s. I say, your desire to sell the property does not give you the right to terminate the tenancy. Then they say, but Mr. Bornstein, they're month-to-month tenants. I've lost the lease, but they've been month-to-month tenants. We'll just serve a 30-day notice. I said, nuh-uh. Rent regulation, eviction control. Got it? You have to have a just cause. The desire to sell a property vacant isn't a just cause under the ordinance. We good on that? Let's go to the top part. The top part is where it becomes interesting for you who are savvy. Single-family homes and condominium units. I told you there's two components of the rent ordinance, eviction rules and rent regulation. Eviction rules are just cause evictions. Rent regulation is when you and under what conditions you can raise and lower the rent. Single-family homes and condominium units, there typically is no rent regulation on those properties. So if you buy a single-family home and the tenant has lived there for 10 years, and it's month-to-month, and the single-family home was built in the 1940s, could you raise the rent-to-market rate after you purchase the property? Yes. A lot of people don't know that. Single-family homes, condominium units, no rent regulation. There are some big exceptions. One of them is if the tenancy started before January 1st, 1996. And you'll see that at the bottom of this chart. So where we have a very long-term tenancy, you will still have rent regulation on that condominium or single-family home. Another exception, which you agents who are in the TIC conversion business, if you bought a duplex as a duplex and you converted it to condominiums, while you own that condominium, since you are the developer, you're still subject to rent regulation for that single-family home or condominium unit, excuse me. Most importantly, for you looking at properties, if you see a property and you're looking for a buyer and the single-family home is rented out, being marketed in San Francisco, tenant occupied, single-family home, that single-family home should be vacant before it's marketed for sale, if all possible. If you represent a buyer, you find out when the property was built, 1930s, the tenancy started in 2001. What could you do once you buy that property? Raise the rent to market rate. Correct? There is no rent regulation. So I'm always looking at condominiums, and if it's tenant occupied, do you know what that means? It means your client doesn't necessarily have to do an owner move and eviction to displace the tenant. What could they do? Raise the rent. Now you're not displacing the tenant, you're raising the rent. The tenant has every right to do what? Pay the increase or decide to leave. Right? But you see, that's an option that may be very intriguing, because you may have a guy who is an investor who isn't going to do an owner move and eviction into a single family home in the Mission because he lives in, I don't know, Sonoma or Napa. But he'd like to basically buy it, maybe renovate it, and sell it. What could he do at time of purchase? Raise the rent, tenant decides to leave, you then can what? Renovate, sell it, deliver it vacant. Got it? Couple nuances. If you have a single-family home with an active in-law unit, you've got a problem because that's treated as a what? Duplex. What does that mean? Rent regulation and just cause eviction control for both units if the building was built when? Before 1979. So when you have accomplished an understanding of this chart, that means you can go on the MLS or whatever service you look, and all you're doing is looking to see single-family home, when was it built? Single-family home, when did the tenancy start? Multi-unit property, when was it built? And I immediately say, oh, multi-unit property built in 1950s, rent regulation, just cause eviction control, protected tenant risk, and also tenant relocation payments. If we have a duplex that was built in 2005, do we have relocation payment obligations? No. Do we have rent regulation? No. Do we have just cause eviction rules? No. Once you've got this chart digested, you're ready to do business in San Francisco. It's not that cumbersome. It's just a matter of sitting down and looking at it, but most importantly, now you have the chart. Put it up in front of your computer and give it out. We're thrilled to offer education to everybody in the real estate industry. We're just thrilled to help you not make the mistake of giving off bad information. And what I will tell you is this. When I tell you you'll be at a strategic advantage, here's a perfect example. There are agents in the South Bay who grew up in San Francisco, and their dear friend from high school is selling their property. They sell and list their single-family home tenant occupied, and it's $1,000 below market tenant occupied when they list it. On the MLS listing, it says subject to tenants' rights and rent control. You know there's two components of rent control. The building was built before 1979, so it's subject to what? Just cause eviction control, but is it subject to rent regulation? No. What can you do when you buy that house? Raise the rent to market rate. More importantly, it's marketed with a below market tenant, and the listing agent doesn't even know that she could have raised the rent to market rate before marketing it for sale. So those are the type of things that I see quite a bit, and the people who work closely with me are typically agents who are savvy, who've come to this class, and they see opportunities where other people don't immediately see them. So I mention that because I welcome smart, strategic assessment of what's possible with the property, and everything's being done properly, legally, ethically. You're entitled to raise the rent to market rate. Before you have a sale of a single-family home, if you represent a seller, you might want to get a long listing agreement and recommend to the seller that they hire me to do a rent increase. I do a rent increase. We wait 60 days. Maybe the tenant gives up possession. Maybe the tenant pays the rent increase. Maybe I'm able to negotiate a voluntary move out in exchange for what? Waiving the rent. but there's all sorts of opportunities that arise as long as you know what the ordinance permits and what the ordinance doesn't. So that's rent control. Let's talk about owner move-in evictions. And I mention this because by and large, if you're in San Francisco and you're running around as a real estate agent, you've got to have a working knowledge of that cheat sheet. You have to understand what's possible with owner move-in evictions and relative move-in evictions. Because fundamentally, if you're representing buyers with the very low vacancy rate in San Francisco, you're going to have buyers looking at property that's tenant occupied. And while you may think it's interesting and great to buy a property for a buyer that's vacant, you're paying top dollar for that vacancy, right? The difference between a tenant occupied property and a vacant property, the same property, literally $100,000, if not more. So what I like you to do is know that, hey, this owner move-in eviction, relative move-in eviction opportunity is not that cumbersome of a process. If you get to an attorney who knows how to handle it, it really is a wonderful segue and stepping stone to building wealth for your clients. So when people come to me and they say, Mr. Bornstein, what type of property would you like me to buy in San Francisco to maximize investment opportunity for me? I'm a first-time home buyer. You know what I'm going to tell them? A tenant-occupied nice property that has good bones. Why? I'm going to want them to do an owner move-in eviction come purchase. Why? Because once they move the tenant out, they know they have to live there for 3 years, but in 3 years they've satisfied the tax shelter time period. 3 years they go ahead and sell the property if they want, and they deliver the property vacant, and guess what? Immediate equity appreciation in the property. It's guaranteed as long as you can transition on the front end the tenant from the property. In order to do an owner move-in eviction, we need to remember a couple rules. First of all, this is the information that I need from a client before I can do an owner move-in eviction. So if you have a client looking at a property and they're in contract, once they're in contract and they say to you, I'm going to be doing an owner move-in eviction, I'm going to send them an OMI information list. I need to know who's been in there, how long have they lived there, how many properties the owner owns. I need to know how many people have lived there, how long they've lived there, whether there are children in the unit. With that information, I can prepare an owner move-in eviction notice. Let me give you an example. In San Mateo County, a termination notice is about 3 paragraphs. In San Francisco, an owner move-in eviction termination notice, 7 pages. Okay? And if you make a mistake in the notice, you have to start over. So the whole game is drafting up that proper notice. In order to do an owner move-in eviction, what must you own? 25% of the property. 25% ownership interest necessary. Do you have to buy the interest? No. Your father can own a duplex. He lives in Burlingame. He wants his son to move into the property, but his son is not on title. Can the father deed a 25% interest in the property to the son and the son then do an owner move-in eviction? Yes. For those of you who represent investors, they want to set up title as LLCs. Well, can an LLC do an owner move-in eviction? No. If you're going to have a client buy a property and they say, I want to set it up as an LLC and I also want to do an owner move-in eviction, what do I tell them? 75% ownership by the LLC, 25% ownership by the owner in his name or her name, or we have total ownership in the person's name, and after they effectuate the owner move-in eviction, will I transfer title into the LLC? Got it? You can either deed it to someone, or you can actually own it. Now, generally speaking, owner move-in evictions are not that difficult of a process as long as you go to the right attorney who does this all the time, and as long as you're dealing with a situation that doesn't look retaliatory. Let me give you an example. First-time home buyer, you bought them, you helped them buy their first duplex, they're moving into the top unit, the tenants live there 2 years, they're month to month. Can you do an owner move-in eviction? Your client rents? Yes. That's relatively easy. The owner needs to prove good faith without ulterior reason to make it their principal place of residence for 36 months. People say, well, how am I going to prove that? Raise your hand, swear under penalty of perjury. You bought the property, have a 30-year mortgage, and you want to live there for 36 months, right? It's rather easy. because you have no history of acrimony with the tenant. You bought the property to move into. Where it becomes more difficult is if you, a savvy real estate investor, have 30 properties throughout the city. You've just been taken to the rent board by a tenant in the Mission, and then you call me up and say, Mr. Bornstein, I want to do an owner move and eviction. I say, oh really? When was the property built? Oh, before 1979. Do you have a history of acrimony with the tenant? Not really, but he just took me to the rent board for a decrease in service petition. I should have won. I say, so now we're going to do an owner move and eviction? Where do you live? St. Francis Wood, and you're going to move into a one-bedroom? Not going to happen. That's where you will have difficulty proving good faith. Generally speaking, though, I welcome you bringing clients who are in contract, who want to do an owner move and eviction, into my office, and I can prepare and educate them about the process, and we tend to find it rather easy to accomplish. The one thing you need to remember, though, is this. I printed out the rent board payment obligations. It's also right to the left, not focused real well. This is in the handout. Importantly, you need to remember every March 1st, the relocation payments go up. Right now, if I buy a duplex with month-to-month tenant up top and they've lived there over a year and it's just a single person, I'm going to be paying $5,551 to displace the person. Half at the time of service of the notice, half when they vacate. If there are 3 people in the unit, the relocation payment is $16,653. Half at the time of service of the notice, half when they vacate. If there are 5 people in the unit, live there over a year, it taps out at $16,000, that 3-person payment. However, we're not done yet. There's another category to the far right. Families with children under 18, disabled people, or elderly people. They get an additional $3,700. So let me give you the example. We do not have protected tenants. We have 2 wonderful elderly people who are taking care of their 16-year-old grandchild in the top unit of that duplex. They've all lived there over a year. Do they get $16,653? Yes. Now, the 2 grandparents are over the age of 60. Do we have to pay another $3,700 to each of them? Yes. Then they're a family unit with a minor child. What we have to do? Another $3,700. So how much does that cost you approximately to displace those 3 people from the property? $28,000. Now, if you're an agent, I like those properties, but you better educate your clients before they come to see me about the need to pay relocation, because nothing is more uncomfortable than me having to explain that I don't get started with representing you until you provide me my retainer and half the relocation payment, because I have to serve the relocation payment with the termination notice. And if you educate your client about it, they're going to be comfortable about it. But if they come in post-purchase and I'm the one telling them they need $29,000 or whatever to do this, they're going to be furious with you. And the goal always is to make you look great in my office, to elevate you, and I have to just be really diplomatic about that discussion. And I emphasize this because if you come into my office or you develop a relationship with Bornstein and Bornstein, the beauty is that we are going to elevate you in a way that you're a knowledge-based real estate agent who can help people make great decisions. We want people to come into the office and say, wow, I can't believe I have to hire an attorney to move into a property that I just overpaid for, and I have to comfort them. I comfort them and say, yes, indeed, it was expensive, but this is the type of property we think is a great starter property for you, because if you work with us, we're going to transition the tenant out legally, properly, and with a relocation payment, and all of a sudden, 3 years from now, when you decide to sell it, or when someone gives you an estimate of what your property's worth, we've elevated you to a $200,000 upside on the property simply by going through that owner move and eviction process. So with that, that is the chart for the relocation payments. A bit about relative move and evictions. Relative move and eviction is where you have a relative moving in to a building. Here's the rule. It used to be you can send your grandchild to every house that you own in the city every 2 years. did away with that. In order to accomplish a relative move-in, the owner has to be in the building or simultaneously seeking possession of the building. So if I have a fourplex and I own one of the units and I'm the owner and I live in one of the units, I can bring a relative into the other 3 units as long as the relative qualifies. Brother, sister, father, mother, grandfather, grandmother, grandchild, granddaughter. As long as I live in the building. Now it also says you can be simultaneously seeking possession of the property. What does that mean? We buy a duplex. There are 2 sets of tenants, month-to-month, non-protected. Can I, as a 100% owner, do an owner move and eviction on the top unit? Yes, no protection. Can I simultaneously have my brother do a relative movement into the bottom unit? Yes, because we are what? I'm simultaneously seeking possession of the premises. What must we prove? Good faith without ulterior reason to make it your principal place of residence for 36 months. Got it? You have to pay relocation? Yes. I've got an extended family right now that's taking back a fourplex right now with each family member taking one of the units with one very big exception. You can't do it if there is a what? Protected tenant in the property. So whenever we're looking at multi-unit properties, we're always on the lookout for whether we have a protected tenant or not. How are you going to know if you have a protected tenant? Well, you're going to, before you remove contingencies, do an assessment of how long the tenants live there and whether you can tell or not whether they're disabled or elderly or whether they complete an estoppel document indicating that they are indeed protected or not. It's my experience in San Francisco that tenants who are indeed protected scream it. Tenants who are not protected don't fill out the information because they don't want to admit they're not protected because that reduces ambiguity, and oftentimes the hope is the ambiguity causes people not to want to buy the property. Another point. You own a building built in 2002. Tenants over the age of 60 and has lived there 12 years. Tenant is given an estoppel document and the tenant fills out the estoppel document saying that they're protected tenant. What's the problem? The building was built in when? 2002. Are there any protected tenants in that situation? No. Have you ever been in a situation where a tenant is claiming protected status, but they can't be protected because of the definition of the property? What do? If you represent the seller, you have me write a letter that is included in the disclosure docs that says, we have reviewed Susan Jacobs' tenant estoppel documentation where she alleges that she's a protected tenant. Be advised, the protected tenant does not apply to a property that was built in 2002. Therefore, Susan is not a protected tenant. She is merely an individual who has lived in the property for this period of time and is this age. You may still be able to terminate the tenancy based upon what? Building built in 2002, there's no rent control, just on 60 days notice. Got it? So when you see a roadblock, if you're representing a seller, you don't let that bad information stick and fester. You clean it up with a letter to the in the disclosures. If you're representing a buyer and everybody's scared, come to me because that's maybe a great opportunity for you to put an aggressive offer in, lock in the property, and then I will confirm by email with you that indeed if the property was built in 2002, there is no protected tenant. And that's an effective use of my knowledge, which is if something is intriguing, if you email me or call me up and say, Mr. Bornstein or Daniel, I've got some interesting opportunity, I just want to confirm that I'm viewing it correctly, I'm going to give you a blessing, or I'm going to say, wait, we've got a little bit of more information we have to gather. So with that, let's go further. Protected tenants. So we have also prepared a protected tenant cheat sheet. It should be in your materials. And rest assured that there's a lot of people running around town with imprecise information about protected tenants. Just like the first chart today, if you can get this chart digested, you're well ahead of the game and you'll be on the lookout for what we consider to be the only situation where we could have a protected tenant. First, there is no protected tenants where we have buildings built after what? June of 1979. So if we're looking at a condominium complex built in 2010, there are no protected tenants. I don't care if they say they're protected, they're not protected. The top part is where you have to be on the lookout. There are no protected tenants in a single-family home or a condominium unit. So if you've got a duplex that was built in the 1940s, converted to condominiums in the 1980s, a seller is selling one of the condominium units. There is no protected tenants in a condominium unit. There is no protected tenants in a single-family home. So we can have a single-family home where the woman has lived there since 1992. She's a month-to-month tenant. Can you raise the rent under Costa-Hawkins? No, because the tenancy started when? Before January 1st of 1996. She writes down that she's a protected tenant because she's lived there for 35 years and she's over the age of 60, but it's a single-family home. She's a month-to-month tenant. What could you do if you do a owner move and eviction? Owner move and eviction. You can't raise the rent because she moved in when? Before 1996. But could you buy it, move in, pay the relocation payment, $5,500 plus because she's elderly? What is she entitled to? 37. So it's an $8,000 to $9,000 relocation payment. The seller was not able to raise the rent, delivered the property with a tenant occupied unit. The place is worth $200,000 more vacant and cleaned up. Your client hires me to effectuate the termination, proper, ethical. You pay the relocation payment, and you've got a great property. And that's out there in San Francisco. It's out there in San Francisco where an owner is not able to displace or get a voluntary move out of a condominium or a single-family home, long-term tenant. Your clients can actually effectuate a termination just like anywhere else in the country, except in San Francisco it's fraught with all sorts of political blowback. But most importantly, if you see this opportunity and you understand it, you'll recognize that despite the fact that the person may have lived there a long time, and despite the fact that the rent is low, you're able to do an owner move and eviction. Got it? Where do we have protected tenants? Protected tenants inhabit multi-unit properties built before 1979. So when we're talking about protected tenants, we're really just looking at duplexes, triplexes, sixplexes, 10-unit properties. And what do we know about the categories of protected tenants? They're down right here. 60 years of age and have lived there over 10 years. Disabled and has lived there over 10 years. And when we put disabled down there, it means they're eligible for SSI. I want to mention that real quickly. It's a high threshold for disability to be protected. And we'll talk about that in a second. And then finally, 5 years in the property and catastrophically ill. 5 years and catastrophically ill. Generally, the general rule is you can't displace a protected tenant through the use of an owner move and eviction or relative move and eviction. So that property will sell for less money because there's a protected tenant who cannot typically be displaced through an owner move and eviction or relative move and eviction. Got it? So if I'm going to be buying a property, I represent a buyer, and I see a triplex, and the top unit of the triplex is someone who's 65 years old and they've lived there 12 years, the property was built in the 1940s, that's a protected tenant. I'm not going to be able to do an owner move and eviction. So that protected tenant who's lived there for 12 years, probably $1,800 below market, gets to exist in there in perpetuity until you have a just cause to evict, or you buy the tenant out, and until that time, you've just got an underperforming unit. Your job as an agent is to, if you represent a seller, see if there's a possibility of transitioning the person out before you market it for sale, if possible. If you're a buyer, before you remove contingencies, you make sure you have a clear understanding of who's protected and who's not. And that is a cat and mouse game. I sometimes hire a private investigator because the risk of making a mistake is so great that it ends up being a very foolish purchase decision if you buy a property that you thought your client's going to move into, only to find out that the person's protected. Now let me point out a couple things about this protected tenant situation. If I have a duplex, building built before 1979, top unit, the tenant has lived there 4 years and they have cancer. Are they catastrophically ill? But have they lived there 5 years? Can you do an owner move and eviction on that person? Yes. What would you have to pay? $5,500 plus an additional payment of what? $3,700 because they're disabled. I have a tenant who has lived in the property 10 years. Same duplex. They have anxiety and they have prescription for Ativan. Are they protected? They work for Muni, right? They're not protected because their disability doesn't rise to a level of severity enough to render them disabled for purposes of that category, but whether they entitled to, under the OMI rules, additional relocation payment of what? $3,700. So we can have tenants in a duplex, they've only lived there a year, but they're entitled to what? $5,500 because they've lived there a year, and then they tell you that they have an arthritic knee that's impacting their ability to actually function on a day-to-day basis. What did they get? $3,700. Now, the reason why I bring this up is as follows. In San Francisco, if you have a person in a duplex who is less than protected but has a disability, do you know what that does if you terminate their tenancy through an owner move and eviction and you displace a disabled person? It tanks your condo conversion. It tanks your condo conversion, which means as follows. When you're looking at your disclosure docs and you see a tenant who says, I'm not protected, that doesn't mean they're not disabled, it just means they're not protected. If you tell your buyer, hey, it's a duplex, a golden duplex, you'll be able to do an owner move and eviction, Mr. Bornstein will help you out, you'll pay your $5,500 and you'll be in a year with your other co-owner down below, be able to transition into a condominium. Guess what? I serve a termination notice. They go to a smart tenant attorney. The tenant attorney asks them 5 questions about their health. Before you know it, they write me a letter, say, thanks, Mr. Bornstein, for the first portion of the relocation. By the way, this person suffers from anxiety, PST or PSD. They're entitled to additional relocation payment. Now, the $3,000 isn't that big of a deal. But you know what the big deal is on that duplex? I now got to tell my client that, hey, we got a problem. They claim they're disabled. We got to pay $3,700, and now we have an impact on your condo conversion. Guess what the attorney for the tenant says? Oh, Mr. Bornstein, we'll be glad to negotiate away the disability. If you would give us another $40,000, we will rescind our claim for disability. We know that that will impact condo conversion rights, and that will impact the value of the property, $200,000. Why don't you pay $40,000? And you know what? Sometimes I recommend it, because if they have real documentation that they have a disability, a mental disability, a health disability, they're not protected, but they impact condo conversion. So why I bring this up is because when you are emphatic nowadays in San Francisco about what's going to happen with your property post-purchase, you create risk liability for yourself. So if I represent a seller, I don't tell people whether they can convert to condominiums. I say it's a duplex. Contact an attorney for an evaluation of what's possible. We're selling the property with the tenants in it. If I am a buyer's agent, I want to make sure you don't go overboard and say, oh, this is eligible for condo conversion. We're not going to know if it's eligible for condo conversion until after the owner move and eviction occurs and no one raises the claim that they're what? Disabled. It's not disability for purposes of protected status. It's disability for purposes of that additional payment. And there are attorneys out there who are arbitraging that component to impact condo conversion rates. We know right now that there's a moratorium on condo conversions for all units above 2 units. 2 units still remain possible to condo convert by fast track, but even those are now compromised by virtue of the new tenant buyout legislation, which we'll cover shortly, and also because of the fact that if you displace a disabled person, you will be impacting your ability to condo convert. That's where it gets tricky, and that's why in some respects coming here to know where there are potential minefields is hopefully helpful. So we know there are no protected tenants in a single-family home or condominium unit. Before I move on, let's talk about this scenario, because you're going to face this. Single-family home in the Richmond district, and they have a beautiful 20-year in-law unit with a 10-year tenant in the in-law unit. In the single-family home, the legal part of the house with the legal kitchen, there's a tenant who is 65 years old and has lived there 12 years. There's another tenant in the in-law unit. Do we have a protected tenant in the main part of the house? Yes. What are we going to do? Well, if I'm representing a buyer, I want a great deal on the property. $200,000 less than what the place would be worth vacant. Why? I'm going to have to transition the person from the in-law unit out. How can I do that? serve a notice of intent to demolish the unit, it's not legal, remove the unit from housing use by pulling permits, restoring the house to a single-family home. Once the tenant is out and I've restored the house to a single-family home, is that tenant in the legal unit in a single-family home? Yes. Do we have protected tenant in a single-family home? No. Got it? So someone's status as a protected tenant can evolve when the tenant attorney representing the tenant in the main house says, wait a second, she's a protected tenant. I say, wait a second. 3-hour report says single-family home. Tax records say single-family home. Utility hookups, single-family home. We removed the illegal structure. My client never collected rent, is just trying to correct the situation, bought the property to move in. Okay? And if any of you, and someone mentioned the rent increase that occurred that made the news the other day. Did anybody read that article? Yeah. All that situation is that there was an in-law unit. They removed the in-law unit. It became a single-family home. The person in the main part of the single-family home had not lived there since before 1996. Single-family home, month-to-month tenant, what could you do? Raise the rent to market rate. That's all that happened. And the tenant was shocked, stunned, and amazed. And all you're doing is allowing yourself to understand the law, and you're entitled to that rent increase. However, you do a massive rent increase on a single-family home, you still are subject to just cause eviction rules in San Francisco. Is non-payment of rent a just cause to evict in San Francisco? Yes. But if the place is in bad condition and you raise the rent $7,000, that tenant can do what? Not pay the rent. There could be habitability issues in the property. You still have to prove good faith without ulterior reason for that eviction. So you've got to be careful with those massive rent increases. What I recommend is before you do a rent increase of that type, you want to do a little bit of research in the community and find out what is market rate for that property. You want to have documentation like you've done some Craigslist looking, or you hire someone to do a rent analysis. As I mentioned, I'm a broker. I work with Bay Property Group. I'm broker of record. If any of you need comp information on fair market rent, please give me a call. I'll be glad to invite you to meet with someone to actually get quick data on what is fair market rent in the San Francisco area, depending upon the amenities of the particular unit. That's an invitation. So this is the protected tenant chart. Do we understand it now? And remember, we could have a person who is elderly, not protected. They would be entitled to additional relocation payment, but you can still displace them through an owner move and eviction. We could have people who are disabled, but they don't qualify for protected status. We just give them additional relocation payment. And we're aware of the fact that a disabled person in a duplex could really impact condo conversion rights. If you've got those two charts down, you're really ahead of the game for people. Let's go over this termination. I'm going to take questions at the end. Let's go over the termination process. If you're going to be in real estate, you really have to have an understanding of the termination process. If you represent a buyer, we have this chart in here. This chart is the same chart of whether it's in San Francisco County, Alameda County, Los Angeles County. This is state law. This is the state process. It doesn't change. If I represent a buyer and we're going to be doing an owner move and eviction, if the tenant has lived there over a year, they're entitled to a 60-day notice. I can only do the owner move-in when I am the record owner. What this means is I serve a 60-day notice, I pay half the relocation, and if the tenant moves out, I'm thrilled. Matter done. I pay the second portion of the relocation, we're done. If the tenant doesn't move out after the 60-day notice, then I have to file what's called an unlawful detainer action. An unlawful detainer action is the trade word for what? Eviction. The tenant is unlawfully detaining possession of the property after the notice has expired. The process from the start of the eviction to the end of the eviction process, 6 to 8 weeks on average. So what we're looking at is if you represent a buyer and they're renting, and they just stretched for a mortgage, and they have to pay a relocation payment of $20,000, they potentially could be 4 months of mortgage payments, 4 months of rent payments, relocation payments, attorney fees before they get into the place, and I have no control over that. Understand? Another point. Once we serve the notice, your client cannot accept a penny past the date the notice expired in rent. Let me give you an example. If I serve a notice March 15th, it will expire in May 15th. If on May 1st your client imprudently takes the full month of rent and deposits it into the bank, what have they done? They've accepted rent past the expiration of the notice and they've reinstituted the tenancy. We have to start the process over again. So every year I got a couple clients who forget, they deposit money and I tell them, I'm sorry, we've got to start over. For you agents, what I recommend we do in order to help our clients get to a point where they can digest the cost and maximize value, we close escrow at the end of the month. We give notification with a new owner at the beginning of the month. We collect April rent, and then we serve the termination notice, April 5th. The notice expires June 5th. April rent can be deposited. May rent can be deposited. June rent, when sent, gets sent back to the tenant because we don't accept a penny more than the actual amount. You can't deposit June rent and then write a check back for the 25 days. That doesn't work. You have to reject the whole payment. Generally speaking, 6 to 8 weeks to work itself through. 99% of all cases settle. They usually settle with the tenant vacating. We waive the rent and give them relocation money. Even if we go forward with an eviction lawsuit, if we win a trial, we still have to pay the relocation money. It's not waivable. We can't subtract unpaid rent against the relocation payments. We have to pay those relocation payments. 6 to 8 weeks. If we do a non-payment of rent case for 3-day notice, we serve the 3-day notice. They didn't pay the rent. We wait 3 days. If on the 4th day they still haven't paid the rent, I can file the eviction action. 6 to 8 weeks to work itself through the eviction. If on the 10th day the tenant offers you the rent, can you reject it? Yes, because you only have to accept it when? During the 3-day notice period. Afterwards, you can reject the payment. If you accept the payment and deposit the money, you lose your case. You've waived your right to enforce that notice. And when you have a working understanding of this, our goal as attorneys is always as follows. As fast and as cheap as possible to get the vacancy, taking into account attorney fees, time, and risk. And when people come to my office, I'm not interested in elongating a dispute. It's really as fast and as cheap as possible, taking into account my time and the risk of the litigation. When you speak that language, people understand that if I'm giving advice, when I say, well, why don't we just waive 45 days rent and have them move out in 45 days, we'll give the security deposit back without offset and we'll pay the relocation. And they say to me, Mr. Bornstein, why are we going to waive 45 days rent? I say, well, 45 days rent is $1,500 because they're a long-term tenant. If I have to go to court and sit at court for 6 hours, that's going to be more than $1,500, and it's likely I'm going to be spending more than 6 hours in court. So it's all about the economics of the dispute, and the attorney should be helping you accomplish your goal as quickly and as cheaply as possible. Litigation is not like a football game or a basketball game where one side wins and the other side loses. Your job is really to use the resource effectively and have your client understand that they're not going to win this dispute. They're looking for the vacancy because the vacancy is what they've actually hired me to accomplish. And my goal is simply to get that vacancy as quickly as possible. And when you work with my office, you'll realize that we just don't do the 4-page written letter demand. We just execute on the goal to get us closer to that vacancy, because ultimately that is what we've been hired to do. Let's move on. So March 7th, 2015. What happened March 7th, 2015? Well, I used to be doing buyout agreements in my office 2 to 3 a week. And every day we're bringing in new buyout agreements. And they used to be very helpful to our clients because if you represent a seller and they want to deliver a duplex vacant, negotiating a deal with the tenant vacating the premises in exchange for financial compensation was wonderful because it would free up a vacancy. Maybe you would offer the tenant $10,000, they vacate, the property is then staged, and the unit sells for $100,000 more out of a $10,000 cost. The Board of Supervisors and the progressive community became aware of how successful these buyouts have been, and they created new legislation that came into effect March 7th. We know that there's a lawsuit against that legislation, and it's pending. But right now we have to follow the new legislation. The new legislation requires what? 45-day right of rescission, which means as follows. And this is in your handout, but generally speaking, you have to disclose that you're going to engage in a negotiated buyout discussion. And then if you reach an agreement, even if it's an assigned agreement that the tenant's going to leave in 60 days for $15,000, they have 45 days after they sign the agreement to rescind their obligation to live up to that agreement. So that throws a lot of confusion into the negotiation. Are we still doing buyout agreements? Absolutely. Are we using the new law? Yes. So we're giving the disclosure, we're negotiating an agreement, we give them notification that they're entitled to rescind the agreement. We used to recommend as follows. Let's say you settle a case, they're going to move out for $20,000 in 2 months. We used to recommend give them $5,000 when they sign the agreement. That gives them motivation to actually live up to their obligation. And then give them $15,000 when they vacate. 99% of the time, people live up to their obligations. Now my recommendation would be on that same $20,000 deal, $5,000 on what day? The 46th day, $15,000 when they vacate. Why? Because if you give people money up front and then they rescind their obligation, you're going to have to chase that money. And it's real hard to get that money back. If a tenant agrees to vacate and doesn't after signing a buyout agreement, can you evict them for violating their promise to vacate? No, it's not a just cause under the rent ordinance. Violation of a buyout agreement is not a just cause to evict. Now, there are ways around this where I can get to an agreement with the tenant, and instead of doing a buyout agreement, I may create a lawsuit that is enforceable through an eviction. It's more cumbersome, more expensive, but on high stakes vacancies, I will do that for people. Generally speaking, just remember, the new buyout regulation, 45-day right of rescission, you have to provide disclosure information, and also importantly, you do buyouts of multiple tenants in a building, you take your ability to condo convert. Multiple tenants who are bought out in a duplex, you take your ability to condo convert. So what they've done is put you in a straitjacket if you own a duplex, because you're not able to utilize a buyout to create the vacancy, to create the opportunity for fast-track condo conversion rights. This doesn't have as much of an impact on triplexes or anything else because there's such a long moratorium. But on duplexes right now, and SFAR has done a wonderful job of putting out all these disclosures, including the new tenant buyout disclosure, where you are put on notice and your clients are put on notice that if there's been multiple buyouts in a building, no condo conversion. If there have been multiple tenants bought out in a building, no condo conversion. If the tenant who you bought out was disabled or elderly, that is no condo conversion. So essentially, hopefully, I think this law will be successfully challenged. But for right now, it's put a big dent in trying to preserve that wonderful fast-track condo conversion right that is no longer available. We used to offer a fixed fee of $500 to do a buyout agreement. We've increased the price a bit because the new buyout regulations are a little bit more cumbersome. Generally speaking, it's about $750 for us to do a buyout agreement. One important point, we don't typically do the negotiations. Why? If I call up a tenant and say, "Hi, I'm Daniel Bornstein. I'm going to be representing the owner of the property you reside in. I wanted to let you know that we're interested in discussing the possibility of you transitioning from the property in exchange for financial compensation. My client's plans for the property are inconsistent with the status quo. We would welcome the opportunity to dialogue." They say, "Oh, thank you very much, Mr. Bornstein." They hang up the phone. They do a database search on me. They say, "Oh," right? Then they get an attorney, and the attorney says, "Hi, Mr. Bornstein, I heard you contacted my client. yeah, we're happy to discuss a buyout. My client's first offer is $150,000 and they'll leave in 30 days, right? So what happens is if I enter into the negotiations, it may enlarge and increase the deal because I end up pushing people to tenants, attorneys. So I like to have the client done properly, meet with the tenant, give the disclosure, and talk to the tenant about their goals, because that may precipitate a better deal for the client than if I get involved in the dialogue. What I do is I stay behind the dialogue, and when a verbal agreement is reached, then I will prepare the necessary documentation. That's generally the way I handle it. If you represent clients who are what I call a bull in a china shop, where they can't have a positive, productive communication with their tenants because they're very excitable, I'm happy to do. We're in the same business, and I say that because all we do all day is manage relationships, and we hope to manage them well. Some relationships are more difficult to manage than others, and if you find that your client is really not the type that's going to be successful in handling a communication event, I'm happy to step in, but it comes with that risk that we end up enlarging and increasing the price point on the deal. Rest assured, though, buyouts are still very attractive, regardless of their impact on condo conversion for sellers, because if I'm a seller, I know that my duplex is going to sell for $150,000 more if that top unit is vacant. I'm going to recommend you give that person $25,000 to move out. If I represent a seller of a single-family home and I can't get a rent increase to cause someone to move out, am I going to give them $20,000 to vacate so I can deliver the single-family home vacant, beautifully staged, clean? Am I going to make $150,000 upside on the property? Yes. So we're still using negotiated voluntary move-outs. We just have to be more aware of the repercussions of the law. And hopefully within the next 6 months, the law will be struck down, like the Ellis 2-year rent differential was struck down, and we'll go back to the old approach that was much more simple. But until that happens, we're stuck. All right, let's talk about short-term vacation rentals. Don't raise your hands. I know some of you are engaged in short-term rentals and you haven't registered with the city. If you've watched the news, I was astonished. About 2 weeks ago, they listed how many people had registered their units for short-term rentals, and it was like 40 people. Right? 40 people in the city. Thousands of units in the city being rented on a short-term basis, and 40 registered. The process is broken, and if you saw the news yesterday, there's supervisors who are going to try to tighten up the legislation. The planning department has already acknowledged that it's impossible to police, which means for some of you who have clients who are stretching for a purchase, and they have a wonderful house they're going to buy, but they have extra space, it's a wonderful opportunity to do a short-term rental in that space and help contribute to a $6,000 a month mortgage. So I think short-term rentals are interesting if you are a owner. If you are a landlord, you've got to be very careful, because if you have occupants who are engaged in short-term rentals, you don't have to permit it. If you have a written lease agreement that says no subletting without prior written consent of the owner, you can strictly enforce that and preclude people from engaging in short-term rentals. As you know, a tenant is only supposed to charge the proportionate share of what they're paying for a short-term rental, and just like everybody else in the city, they're probably ignoring it. What I have done is there is a law being bandied about in Sacramento trying to regulate short-term rentals, and also I took this right off the planning department's website, the SF ordinance. If you read these 3 pages or 2 pages on what you have to do to register, you will get a fair understanding of what the rules are in San Francisco currently about registering a short-term rental. I have no comment on whether I think it's a good idea or not. I just know that only 40 people have registered. So it's up to you to make your own decision. Another point. One other new piece of legislation. In-law units. So we have a new policy to potentially allow for legalization of in-law units. Very few people have taken the opportunity to legalize an in-law unit. Let's talk about why it may not be interesting. If you own a single-family home and you have an unwarranted unit, if you legalize the unit, what have you made that single-family home?
Duplex.
And what do you have with the duplex built before 1979? Rent regulation, eviction control, and potentially what? Protected tenants. I don't want to take a single-family home with an in-law unit and legalize the in-law unit. If you need rental income out of that space down below, what you would want to do is have roommates in that space, because under the rent ordinance, if you live in a single-family home and you own the single-family home and you have roommates inside the house, you can evict without just cause. An owner who resides in the same unit as their roommates can evict without just cause. So you can terminate the tenancy. When you create an in-law unit, you segregate the space where you create a separate tenancy, and then you're subject to just cause eviction rules. So the legislation on in-law unit, while it seems interesting, it is not really interesting for the vast majority of people who have in-law units, which are those people who live in single-family homes in the Richmond and Sunset District. If you own a triplex or a sixplex and you have space that was converted, that's more interesting because that has no impact on rent regulation, and there legalizing a space may be more intriguing because then that additional income could be treated for purposes of what? Mortgage and refinancing, which may be interesting for you. So even that new legislation hasn't had the impact that the city thought it would have because it's very cumbersome to legalize the unit, and it doesn't make that much sense to do it on a single-family home. So with that stated, I wanted to let you know, I don't know, some of you have come up to me and said, thank you very much for the videos. Please recognize we've handed out flyers and other stuff. I'm trying desperately to be out there on social media, whether it's my Facebook page, Twitter, or YouTube. Please sign up. I'm sending out weekly video updates, so when the law changes, I'm going to bring you up to date with the law, providing you links and downloads. The goal is just to help you, obviously, stay aware of new laws, get up-to-date information, and of course, for my own use of business development. So when you come here and you enjoy the seminar, I welcome the opportunity to have a great relationship. Some of you are clients, and so I'm thankful and appreciative of the business, and some of you hopefully will become clients. The goal ultimately is to help you make great decisions for your clients, and this stuff is tricky. And I say it's tricky because if you talk to 3 attorneys, you'll get 4 opinions, right? And it can become very confusing and cumbersome with a very important point. So you get a recommendation to an attorney because he's a friend of a friend, and your friend says, oh, he's a real estate attorney. A real estate attorney doesn't tell you anything about what they do. So when you're selecting someone to help you with a landlord-tenant dispute, you really need to know, does this person do landlord-tenant law on a daily basis? A real estate attorney may do broker-agent liability. They may do property line disputes. They may do buy-sell disputes. You really need to have someone who is doing terminations of tenancies in San Francisco, owner move-in evictions in San Francisco, so that they're able to see over the horizon of the dispute. Because most of the time, if you call me up and you say my client wants to buy this property, it's a pre-60 single-family home, it was chopped up into individual units, my client wants to move in and do an owner move-in eviction, but there's 4 leases and individual people renting out individual rooms. That's tricky, right? Because there's 4 leases, 4 different tenancies, what are we going to do? If you're not used to those type of fact patterns, an attorney is just as blind as everybody else about how you're going to accomplish that goal. I invite you to consider myself and Bornstein and Bay Property Group for working with you. We have a full-service brokerage as well as a property management arm. And with that, that's the end of my discussion. I'm happy to answer questions. My experience is that people's questions are usually very germane for people to listen. You're welcome to transition out as you want. I'm going to just keep taking questions as the questions arise. I hope you found this helpful, and I will be glad. I would be glad to come back here and continue to do this as people desire this discussion. Go ahead.
What is the definition of when it was built? If I bought something that was built in 1960 for $1 million today, and I spent $2 million tearing up inside and rebuilding from foundation up, is it still built in 1960 even though I spend majority of the construction money today?
Very good question. Generally speaking, the definition is when the first certificate of occupancy was issued for the property. The first certificate of occupancy. There is a provision in the rent ordinance that you can decontrol a property where there has been substantial rehab, but it's a tricky one. It's not a high percentage victory, and you really have to do a substantial amount of renovation. It isn't necessarily tethered to how much you spent, because some people can spend a lot on the facade or fixtures. It has to do with what happened to that building. So if they're burnt to the ground, you may have the ability to decontrol it. Another point, and I have this. Someone bought a single-family home built in 1950s. They dug out the basement and created another unit. They got a new certificate of occupancy for that other unit. That other unit, though, was built within the envelope of the building. That unit is going to be subject to rent control. Different fact pattern. I have a single-family home. A person decides we're going to add a unit on top of the building. The single-family home was built in 1945. This top part got its certificate of occupancy issued in 2003. Is it inside the envelope of the structure? No, it's outside. There we have a hybrid. One unit subject, one unit not. Another point, very important in San Francisco to understand it. We go to 3rd Street, and there's some beautiful industrial buildings. The buildings were industrial use for 100 years, and then in 1985 they were converted to residential live-work structures. When was the first certificate of occupancy for residential use permitted? 1985. Not rent control, no just cause eviction. The building is 100 years old. Got it? You got to watch what the first usage. Don't get confused. Another fact pattern, a lot of people don't know. This is a very nice opportunity for you who are savvy. Mixed use. You got mixed use all over the Sunset, all over the Richmond. Commercial down below, one residential above. Building built in 1935. Single family home is that single unit above. What can we do with that unit above? No rent regulation. No rent regulation on that unit above. It's treated as a single family home. A lot of people don't know that. So a mixed use, one commercial, one residential. That residential, no rent control. Tenant takes you to the rent board claiming the decrease in service because you took away something. If you know your business, you go to the rent board and you say to the rent board, you don't have jurisdiction over this tenancy for purposes of adjusting rent because it's treated as a single-family home because there's only one residential unit on that property. If you have a mixed-use property with two residential, treat it as a duplex. Okay?
That's condo conversion without the water. If you do it
Very
right,
interesting. Commercial down below, two residential above, it's treated as a what? Duplex. Potential for condo conversion.
How about if it's two separate buildings on the lot?
Two separate buildings on the
The
lot is
front
treated
is
as a duplex.
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 How about a building was fine and then they rebuild it in Oakland, mixed use, they rebuild in Oakland.
If the building was burned to the ground, you're likely to be treated as new construction. Now, I had a case where a client picked up an old building, moved it to a new location, got a new address and a new certificate of occupancy. Tenant took him to the rent board. The rent board ruled that, hey, the original certificate of occupancy for that building, pre-1979, you're subject to the rent ordinance. So,
that's terrible.
lots of nuances. And here's the thing. One thing you can recognize is you can hypothetical an attorney to death, right? And one of the things that one of the strengths I think that I have is I'm not going to get you down a rabbit hole of complexity. There's lots of complexity. If you can get this general information digested, that's 85–90% of the game. The tricky stuff, you come to a meeting and we really investigate. Generally speaking, you want to have a good working knowledge of the information I brought to you the first hour, then you're ready to see opportunities, and when something's strange, then you come to me. Strange is single-family home where the person rented out 5 different units, there's 5 written lease agreements, tenants came in at different times. Your buyer wants to buy the property, no one's buying the property because they don't know what to do with the property. Can you do one owner move-in eviction on the single-family home, or are there 5 tenants? Tricky.
How
Tricky.
does the rent board look at that?
What? The rent board, I will tell you that the rent board will treat it as 5 separate tenancies. What I would try to do in that situation, it's a single-family home, I try to have a heart-to-heart with everybody in that building and say, look, this is illegal, it's a boarding house, it's not zoned for boarding. I will gladly have all of you sign one lease agreement. You can all still pay me by one check, but we're gonna have one lease agreement all month to month. They all sign one lease agreement. You take the little locks off the doors, because it's a fire hazard to have those locks, padlocks on doors. One tenancy, month to month. 60 days later, what do you have? A single-family home, month to month, with 5 tenants in it. What could you do? Raise the rent or owner move an eviction. Are they going to be upset? Of course. But what you've done is cleaned up a boarding situation without eviction, but simply getting back onto a written lease. Go ahead.
Okay, so I get a listing, single-family home, and eventually find out that the in-law is being occupied.
Hmm?
So can I, let's say, use the rent increase because it's but then there's a tenant, so no?
If there's an active tenant in the in-law unit and there's active tenant in the house, then we cannot raise the rent to market
Even
rate.
as a single-family home?
Even if it's a single family. That's why the issue of in-law units are it's so problematic. All things being equal, you don't really want to have an in-law unit. Instead, you want to have a large house with lots of people paying a lot of rent. And when you're ready to do a rent increase, you do a rent increase. Another question on single-family homes. Single-family home, the tenants subleased the in-law unit. The tenants pay one rent. Can you raise the rent to market rate? Yes, because your client didn't create the in-law unit. Your client created one single-family home. The tenants rented the in-law unit. Go ahead.
In your example about the situation, couldn't it be construed as bad faith if you got rid of a in-law tenant because it was not legal? I thought the city is now looking favorably upon in-law units.
Very, very good question. And here's the response. The city has created a belief that we want to enlarge the housing stock, so we're going to treat in-law units different than they used to. It used to be I could pull permits over the counter, serve a termination notice, and know that the Board of Permit Appeals is going to authorize the removal of the in-law unit because it's not legal. Now it's a little bit more tricky because it's a political hot potato. Generally speaking, I still recommend if you are a new buyer and you buy a single-family home with an in-law unit, I still recommend you can still remove the unit. You would serve a 30-day notice of intent to demolish the unit from housing. Then you would pull permits. Then, after the 30-day notice expires, you would serve a termination notice for removing the unit from housing use. The risk is the tenant files an appeal at the Board of Permit Appeals or seeks discretionary review. Then you can get delayed into the bureaucracy of removing a unit. But all things being equal, you don't have to continue an endeavor that is not legal.
And
What does that mean? It means that public policy doesn't require you to continue to be in something that is not permissible. This is important. If I'm representing a seller and they've put a person in an in-law unit and the person's been in the in-law unit for 6 years, so you've taken 72 cycles of rent, I'm going to only want the seller to negotiate a voluntary buyout before selling it. If they can't get that tenant in the in-law unit out, we're just going to disclose there's someone in an unwarranted unit. A buyer who comes in who has never collected rent, who's just trying to clean up the situation, will have a much easier time removing the unit than a seller who's been putting the person in and collecting the rent. It still comes with risk, But the Board of Permit Appeals is still going to be tasked with learning, is it a legal unit? Was the kitchen put without permits? A new buyer can restore it to its legal use. The risk, though, is now it can get caught up in the planning department. It can get caught up at the Department of the Board of Permit Appeals. So that if you're going to be buying a property with an in-law unit and your whole goal is to remove it, you should be getting a premium on that property because you're taking on the heavy lifting of a landlord who wasn't able to actually deal with the issue.
So just
What
to
about
back
if the
up
tenant
on
to
that,
protect the
just to
tenant?
back up on that, the upstairs unit, if it was tenant occupied,
Mhm.
and you came and at that point raised your rent to market,
Mhm.
isn't that also considered bad faith? Because they can say that your whole motive was to get a tenant out
Mhm.
in order to now have a single family home that is not under rent control.
And you know, that's a very, what I would say is that is a very fair narrative. And in law, what we have are competing narratives. So that will be a narrative that a tenant attorney will articulate in order to defend the tenant from having to pay the rent increase. And my narrative will be, it wasn't legal to begin with. My client just corrected something that they inherited, and it's a single-family home, and all they're doing is what the law allows is a rent increase. In that dynamic and that dispute, ultimately it will be a jury or a judge to decide whether it's appropriate. What I'm saying is that you have the right to proceed with that. Generally speaking, 99% of all cases settle, so I may be aggressive with the expectation that if ultimately it becomes a very difficult process, I may write a check to have the person voluntarily move out. But you have the right to do this, and I've done it. It gets more and more tricky the longer a person's in a in-law unit, and I certainly don't recommend removing an in-law unit when you've put the person in and you've collected eight cycles of rent on it. One last point on that. If I represent a buyer and I'm buying a single-family home with an in-law unit, I may demand as part of removing a contingency that the seller indemnify me, hold me harmless, and provide a defense in the event we all get sued by the tenant once we try to remove the in-law unit. If I represent a seller, I want to buy out the tenant before we start marketing it, and I want you to know this. You represent a seller who sells a single-family home with an in-law unit. The new buyer does a move-in and tries to remove the unit. The tenant can turn around and sue you after you sold it for having collected the rent and put them in the in-law unit. So you still have residue and liability even though you sold the property. You can sue 2 years later. Go ahead.
What's the expected timeline on resolution of the buyout lawsuit?
I have no idea. They filed the lawsuit, I think, at the beginning of this week or last week, and they didn't ask for an injunction precluding the enforcement of the current rules, so it could be 6 to 8 months. Go ahead.
If you had a single-family home with a legal in-law and a protected tenant, and they don't want to negotiate a buyout, would you recommend doing an Ellis eviction?
I think that would be if you have no other choice, the answer is yes.
Is there a big downside?
Single-family home with a legal or unwarranted unit.
Legal.
Legal. Well, if it's a single-family home with a sort of legalized in-law unit, I don't know that you have much options if the only goal for you is to actually have the vacancy for the use of the property. Go ahead.
Yeah, I know of a situation in the outer mission where there is a single family home and there's a legal in-law that is occupied by the owner. And then he rented the top floor.
Right.
And then before he was able to remove the tenant, he had to pay something like $45,000. Now what happened there?
I don't know. I mean, I have lots of, intermittently I have owners who live in the in-law unit, and they usually justify living in the in-law unit because they need the rental income from the main part of the house to sustain their life.
So therefore now he is so traumatized, he will not even get a renter for that upstairs.
That's unfortunate.
Why doesn't he live there and enjoy it?
Excuse me?
Why doesn't he live there rather than live there?
Go ahead. I'll answer everybody. Go ahead.
So if the tenant claims protection or disability, what sort of proof are they required to provide for disclosure purposes? And second quick question is, can a tenant require you to people to show ID and business cards before they allow them to see their unit?
Second question, no. A tenant can't force someone to show ID if you properly posted a notice of entry. However, if your goal is to accomplish a sale, sometimes I capitulate with unreasonable demands because it solves the bigger problem. Right? Sometimes I work out deals, not because it's not because it's right, but because it's necessary. So I may have a recalcitrant tenant who's going to throw up all these roadblocks, but I bring them down and I say, look, you know what? I understand you have some real concerns. I want to emphasize that we want to make this as problematic for you as least problematic as possible.
Yeah, it's problematic, yeah, right.
Here's what I offer. We're going to try to get this thing sold as quickly as possible so it's not disruptive. If you're cooperative, at the end of this, I will give you $300. And what you do is you pay it afterwards so you get sort of compliance. If they require sign-ins, I give them sign-ins if it's reasonable, if they're not asking for too much. But if they're starting to become so problematic that they're impacting your ability to sell, under the rent ordinance, you can evict someone after you've served them a notice of entry and they continue to refuse entry after being given written notice to cease. So I often will serve a 3-day notice to cure or quit with a 24-hour notice of entry to see if that person's going to allow entry. For a seller, we got to get people in there. The double-edged sword, or the bittersweet aspect of that, is the more it looks like the tenant's a pain, the lower the price is. So we want to be judicious in not enlarging a dispute, because then you have to disclose it, and then people become reticent, and then all of a sudden, what you thought was going to be an easy sell becomes difficult because everybody's scared of this tenant. And you don't want to have a written campaign with the tenant, so we want to be judicious and smart about how to actually effectuate it. If a tenant claims they're disabled, you're certainly entitled to ask them for proof, but in the disclosure requirement, where they just sign a protected tenant statement, there's no obligation that they provide documentation. When you serve a termination notice, you're certainly entitled to, before you make a relocation payment with the additional money, ask for additional documentation. But as part of the sales process, if a tenant says they're protected, there's no obligation that they come up with the additional documentation. If you think it's false, though, you can have an attorney write them a letter saying, we believe that this is not credible. Be advised you're impacting the value of the building. And if, in fact, we find that you are not being honest in your statement, you will be subject to potential liability for having impacted a business advantage of the owner. And then I can kindly ask them to rescind their claim of protected status. But you're not allowed, by virtue of the fact that they say that they're protected, at the time of the actual sales, to investigate all of their claimed allegations.
Can't you ask them for like a copy of their driver's license to prove their age?
Well, you could ask for it, but they don't have to
They
give it
don't
to you.
have to,
They don't
okay.
have to give it to you. Go ahead.
So you're buying you have a client who wants to buy a 2-unit building with the purpose of condo conversion. There's a tenancy, they've been estoppel, let's say one tenant, and they say they're not protected and they're not disabled. Then you said, but you find out later they are disabled, and that could prevent the condo conversion, correct?
That's correct.
So how can we help guide our clients? We don't know, they say they're not disabled, but they still could be, and they're trying to assess what the cost is.
Very good question. What I think we have to remember is there's 2 levels of disability. There's disability for protected status that you have to be eligible for SSI, and then there's disability for entitlement of additional relocation payment that also tanks condo conversion. And when some tenant signs an estoppel regarding their protected status, it's really talking about protected status, not low-level disability. For you, how do you guide your clients? You don't make emphatic statements about condo conversion. You make statements about, why don't you talk to Mr. Bornstein, and he will guide you into this process. And that's fair to do, because you know when they come into my office, I'm going to also tell them, I don't know if you're going to be able to condo convert until I know whether they raise the issue of being protected or being disabled or not. And a lot of the times, the biggest variable in my success is which attorney they get and how ferocious they fight. And there are some attorneys who religiously are sending out requests for additional relocation money for disability payments, and it has significant impact. And if they come with a letter that comes with a doctor's statement that someone's got post-traumatic stress disorder, and my client says, that's bogus, we're going to challenge it. I tell my client, are you really going to hire an attorney, a medical practitioner to investigate this medical doctor's statement? Pay the relocation money. Because if you don't pay that additional disability payment, you lose your owner move and eviction. They hired me to get into the property. They didn't hire me to successfully condo convert their property. It's unfortunate. I can oftentimes try to negotiate the rescission of it, and I do a lot of, we start an owner move and eviction, and then I try to get a complete waiver of claims in the middle of the owner move and eviction, so the person leaves, they get additional money, and they promise that they're not going to sue my client if my client doesn't live there for 3 years.
Just a quick follow-up, so what's the usual buyout or settlement amount?
All over it's all over the case. I'll give you an example. I have a client, they bought a duplex in Potrero Hill. They have a long-term tenant. When I was representing the seller, we were trying to buy the tenant out. She wouldn't be bought out for anything. The buyers hired me to do a relative move-in. They're already in the vacant unit. They're bringing their mother into the other unit. Now the mother is going to take care of the child, but the mother's a free spirit and doesn't really know if she's going to live there for 36 months straight. We do a relative move-in. The attorney the tenant gets is the same attorney who was trying to do the buyout. Attorney says, this is all bogus. I say, it's not bogus. The mother doesn't live in North Carolina, closed down her psychiatric practice, rented out her house, is in Mexico waiting for her daughter to give birth because she's going to be helping with raising the child. He says, don't believe it. I say, it's happening. He says, well, do you want a complete release? I say, absolutely, we'd consider it. What do you want? $40,000. So instead of paying $5,500 to buy out the tenant, to do an owner move-in, for $40,000, my client has freedom of use of that property without the risk that the mother isn't going to live there for 36 months. My client gets the property in 5 years. If they decide to grow out of the property, she delivers the duplex vacant in 5 years and has already locked in upside from that property. The problem is that it's very dangerous to know whether you're going to be able to condo convert a property until you learn if they're going to be raising that issue of disability status. I have no control over it. And when people come into my office and they say, how difficult is this going to be? I tell them, it's a roulette wheel. I have no control over what happens until I know which attorney they get and what they're claiming. Sometimes things that look very, very difficult play out and they become real easy. And the client says, oh, Mr. Bornstein, you're wonderful. And in the back of my mind, I'm like, you were lucky. Right? Then I have cases, they seem to be easy, and then all of a sudden they turn on me and become terribly difficult. It has nothing to do with what's going on in my office. It just has to do with the statistics of an outlier of a case. Most importantly, that you have to be very careful about what you say on these duplexes now until we get greater clarity, because you can't guarantee condo conversion.
What do you do with the ferocious lawyer against you?
I pray.
Too bad the guy in the intermission didn't get a lawyer ahead of time.
That's being sold with a tenant in it for a year.
Mm-hmm.
The building was built in 1922.
Mm-hmm.
It was converted to condominiums in 1996.
Mm-hmm.
Is there going to be a problem after the lease period if the buyer can they move into the unit without any problem?
The buyer can do an owner move and eviction. The buyer, it's still a pre-79 building. It's not when the condo was converted, it's when the building was built. The buyer can buy the building and move in, the buyer can buy the condo and move in through an owner move and eviction. The tenant has lived there over a year, they're entitled to $5,500, there's no protected tenant. The buyer can also, if the rent is low, can raise the rent to market rate. Now, a lot of times I'll have a discussion with the buyer. Tenant attorneys are smart. If I buy it and I immediately try to raise the rent to $5,000 after I buy it, tenant attorney's going to say, this is a pretext. You just don't want to do an owner move and eviction. My client's not going to pay the increase. They're going to sue you. So you have to be judicious. Sometimes it's easier to just do an owner move and eviction and pay $5,500 than to try to arbitrage that rent increase. It depends upon the situation. And it also depends upon what the rent is. If my client just 2 months ago raised the rent, it's not really interesting for me to recommend another rent increase.
And that condo is not under rent control.
It's not subject to rent regulation. It is subject to just cause eviction control. Go ahead.
If I'm representing a buyer who's considering buying a TIC, one of 2 units in a brand new TIC, and is being told, oh, you fast track condo convert. The developer of the TIC units has signed, obviously been done. He's gotten the prior tenants out.
Mm-hmm.
And obviously it was done before the new 45-day law went into effect.
Mm-hmm.
Is it safe to assume that we can still condo convert in a year? Or is that, in other words, what's the retroactivity?
You won't know if your client is buying and doing an owner move and eviction. You will not know whether you can condo convert.
No, it's empty already.
It's empty. Then I think you would have no problem with condo conversion.
Even though the tenant buyouts they did.
I would like to
look.
look.
45-day rescission.
Yeah, I would like to look at the buyout, and then I would go to the rent board and see if there's any no-fault evictions. At the rent board website, you can go to the rent board and look at the history of the units, because that's where they actually mark down whether there's been a disabled person or a protected tenant displaced. So you look at the documentation they provide, and then you double check at the rent board the forensic history of filings at that property. And with that, then you can feel reasonably confident. Go ahead. I'm sorry. Go ahead.
I have an answer to one question. I think somebody here asked about how long for the lawsuit, and Jay was in here, he said 6 months.
Yeah.
Maybe. Number 2, the Ellis Act is coming back. It's going to be heard at the Senate hearing. April 14th, there's going to be a bus or 2 going up to Sacramento, so you're going to be hearing more about that. And then my third thing is, how often do you run into tenants who have lived in an unwarranted unit ever coming back to the seller down the road and asking for back rent because it was an illegal unit?
They tend to do it if they get evicted through a termination by the new buyer. That's what happens. It precipitates it when the new buyer comes in and terminates the tenancy. If a tenant goes to a good tenant attorney who's going to file an affirmative lawsuit, they name the former owner because the former owner has been collecting the money in that pocket. Which means this: if you're renting an in-law unit or you represent a client renting an in-law unit, the best thing to do is negotiate a voluntary move-out for money, because the money is not just the sole thing you're giving them. You're also getting a complete release of claims. So when you're done with the relationship, you want to cauterize risk by getting a full release. And that's why I like to do buyouts of in-law units, because there's no residue. If you leave a tenant in an in-law unit after you sell it, you think you've made a lot of money, but you don't realize that that could be disgorged. And a lot of owners who own single-family homes with in-law units, the type of insurance they have is homeowners insurance, because they used to live in the house, then they rented out the house, then they rented out the in-law unit. When they get sued for wrongful eviction, they have no coverage. Yeah. Then it becomes miserable. And I'm sorry,
Single-family home owner occupies the main house,
Mm-hmm.
and there's a tenant, so you do a buyout.
Mm-hmm.
Does this tenant still have the 45-day?
Yeah.
Okay.
Yeah.
Presumably that's still.
It's a buyout. It's a buyout. If it's a pre-79 structure, you have to. What?
Do you think that's going to get?
I don't think it makes a difference, because it's a single-family home, and if your client is going to sell the property and deliver the property vacant, you just wait for that tenant to move out and then stage the property.
Yeah.
Make sure you have a good buyout agreement. I haven't.
So 2 units pre-79, one tenant bought out in October of last year. The existing tenant is going to be bought out this spring, after March 7th. Would that be able to be condo converted or not?
I believe so. I believe so.
Not multiple tenant buyouts?
Yeah, there's more than one tenant in the unit.
In the current
In
unit?
the current unit,
That's a
gonna be bought
problem.
out.
That's a problem. See, if you get, you're here at the SFAR, which is a wonderful organization. I've had a ongoing discussion with one of the people who is crafting an assessment of what it means to buy out multiple tenants. they believe the new legislation says if you buy out multiple tenants, it impacts condo conversion rights.
Even if they're all in one unit.
Even if they're all in one unit. Now, it used to be if you had more than one no-fault eviction, it impacts condo conversion rights. You can only have one no-fault. I read the legislation to mean more than two buyouts in 2 units. The representative of SFAR has claimed multiple tenants, one buyout agreement tanks condo conversion rights. Hopefully that will
So
be.
it's a gray area.
Well, it's an interpretation of the language. If you look at the disclosure docs for when you disclose, it says multiple units. When you look at the legislation, it says tenants. So if you have multiple tenants, one buyout agreement, even if it's one unit, condo conversion is tanked, which is terrible. But
So this is sort of similar to that. So in a duplex, the owner occupies the upper unit. Downstairs, there were 2 tenants, and one moved out voluntarily. It's gone, they broke up, they, to get that person off of the lease, you would need to do that, right? If you don't wanna have to end up buying out 2 people, I mean, how do you deal with that?
if the tenant vacated,
Right?
then you just document that they're no longer in the premises. If it's a month-to-month lease agreement, you just send a letter memorializing that they're no longer in the premises and
Get that
they've vacated.
notarized? I mean, like,
Did the tenant give you notification that they're leaving?
so the tenant.
Who was departed? If they
so
gave you
it's a couple, and
Right.
they broke up, and the woman moved away.
Yeah.
And so the owner has asked for her to give a letter saying that she has vacated, but she has refused to do that. So.
Well, then what I would do is memorialize it. I mean, you can beg documentation or you can memorialize it. So memorializing is, dear, you write to both of them. Please note, I've recognized that you moved out on this date. If my understanding is incorrect, please send me a letter confirming that you're still in possession. If I don't hear from you by this time, I'll consider that you are no longer in possession of the premises.
And then she can buy out the other tenant, and then, but you can't, can she condo convert the 2-unit building, or no,
She has to have another co-owner.
Yeah.
So
Okay.
until she has a co-owner living in the bottom unit for a year at a 25% ownership interest, she can't. Go ahead.
So my understanding is that there's a public database now for these buyouts. What's the downside of this database? You know, anyone in the public can reach the database? They have to go to the rent board to access that database?
The rent board's supposed to keep track of these buyouts, and they're also supposed to keep track of the amount of the buyout. And one of the reasons why they are challenging this is that it's private information that should be publicized. The impact of it is that many people, tenants included, may not want you to know how much they receive. So it cuts both ways. I know that there are some prominent tenant attorneys in the city who are not real thrilled about this whole new status as well.
Today, if we do a buyout, our name goes into.
You're supposed to register the buyout and file the buyout agreement with the city at the rent board, and they're supposed to keep track of it.
My question was related to that in, what's the downside of just not registering it and saying, you know, why register it? I mean, who's gonna force you to register it?
Let me respond by this. I don't know that there's any downside. I don't know, except for the potential that you're violation of the law, and that a tenant who was subject to the buyout agreement, if you don't follow the procedure, can turn around and say you violated my obligations, or you violated your procedural obligations in this process.
But that seems like a much smaller risk than losing your condo conversion.
That is a prudent decision, except for to the extent at some point in time when you do a condo conversion, they're going to have you sign something under penalty of perjury, whether you actually displaced a elderly person or did a buyout, and then you'll have a very significant ethical decision as to what you want to do. And yes, you're kind of hanging yourself if all of this stuff is filed at the rent board. Go ahead.
Can you comment a little bit on principal residence? If you can prove it's not a principal residence, then it's not subject to rent control, is that correct?
No. Principal residence typically, you're talking about when you can decontrol a unit because of Costa-Hawkins.
Well, where I'm going is, a tenant lives in Reno. They have an apartment in San Francisco. They spend 75% of their time in Reno. is their tenancy still subject to rent control?
Under the rent ordinance, it's called a 121 petition. If a tenant no longer makes that unit their principal place of residence and there's no other tenant in that unit, you can petition for a rent increase.
The rent increase?
Yeah.
Yeah, exactly.
To
that's what I
market
thought.
or?
To market. But the thing is, you've got to prove before you're entitled to the rent increase on that pied-à-terre, that secondary home, you got to have a hearing at the rent board. You have to prove that they're not making it their principal place of residence. And I've lost a couple of them that were what I thought were very clear, because a tenant who's in New York on a traveling theater group, right, who pays their taxes in California, even though the tenant hasn't been in California for a long time, they say they're out of town for work-related issues. And if they come to the hearing with driver's license, taxes, medical records, bank statements, you're going to lose despite the fact that they're never there. There is, at the rent board website, if you put in 121, they will give you the actual metrics of how to prove that case. Go ahead. And it's after 4:30, so before we end, I want to thank everybody for being here. And